as well. Okay, so as I said to your colleagues, we will first finish just few slides that we didn't have time to do yesterday, but as topics really overlap, and as I said, feminist judgment is all about gender equality, exactly as the topic for yesterday's class. You know that I didn't give you a presentation for a reason, because I wanted that we watch this short video together. So this is the first thing that I would like to do. You remember that yesterday we spoke about some meanings, about the definitions and elements of definitions, forms of discrimination, but we also spoke about stereotypes. So I hope that I'll manage to do this. So this video is pretty short, but I really hope that I'll manage to show you. And I would like to hear your reactions to this film. And I'm really sorry because the computer was restarted, so it's pretty slow at the moment. So thank you for your patience. Okay, so here we are. I will stop it for a second, share it, and please let me know if you can hear it, okay? Something's happening with the computer. I'm so sorry. I'll try to stop it and to do it once again. If you manage, if not, then it will be your homework, unfortunately. Yeah. It's not responding. I don't know what's going on. Why it is so. So I'll try one more time. If not, no, we cannot hear.
We have a picture now. We can see.
Okay, great. If you can't hear so much of voice, then I'll put subtitles. Can you see?
We can see the video, yes.
Okay, great.
Look Look at this. Look at this. Do you like a dolly? Should we go for the dolly? There's a good girl. You're a good little girl, aren't you, Sophie? Look, what does this say? Sweet dreams. Sweet dreams. Ooh, look at this, Sophie. Meow, meow. I think she liked that pink dolly the best.
If I were to tell you actually that Sophie is Edward,
Ah.
does that change anything?
I maybe thought, oh, this is a little girl, so I have to give her little girl things.
Hello. 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 Come on.
What's this one? What's that one do? Is that a robot? What about this? You like that one? What does this one do? Oliver. Oliver.
You've gone for, you could say, boy toys for this boy.
Possibly in my subconscious, but for me, I was just going for what was around me, but then perhaps my subconscious was automatically playing a trick on me that I was...
If I tell you that he is actually a girl.
Really?
Yes.
Oh, wow. That's really interesting. I suppose it's because of the stereotype.
And then that changed your behaviour towards the child.
It did.
And your behaviour was quite directive.
Did. 1, 2, 3. Beep, 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 beep. Do you want to see my robot?
She's picked up the robot, the car, the puzzle game. I think she's been much more physical in handling the child than the other adults have been with girls.
That really astounded me because I thought that I was somebody that had a really open mind.
Surprise. So I automatically went for the pink fluffy toy because I said it was a girl, so I was sort of stereotyping.
I've always thought I was rather more open-minded than that, and I would think, you know, these are children's toys, whatever the gender.
It will make me think the next time I'm with a child, so my niece or my nephew, to make sure that I am actually being sort of fair and equal with all of them, and just giving each child an opportunity to just be whoever they are.
Okay, hopefully it was a short video because it was hard to watch without the sound, but at least you understood what this film is about. Is there any reaction to what we've seen? Anything that was particularly interesting?
I think that the entire idea behind the video is interesting. It explores how biological gender affects toy preferences in children. That's a very interesting topic. When it comes to very young children, we socialize them in various ways, and this creates preferences very early on. So it's important to test just how much of certain things we see as inherent to a gender is actually socially learned and what is biological. Mm-hmm. I think there are experiments of this type done on monkeys as well and on certain animals, but it's been a while since I've looked into it personally. I think it's a very interesting topic.
Mm-hmm. Alexander, thank you so much. Any other comments?
Well, I believe...
Ksenia, so I don't know if you can hear, Dushenka was already starting to...
Yes, I understood.
I'm so sorry because it's very hard to
don't worry.
Discussion in this format.
I would say that I'm not surprised, but after the evaluation, a couple of them said, but I consider myself open. They were in a moderated situation, so they volunteered to, I don't know, play with it.
Exactly.
So because they were monitored doing that, maybe they also wanted to perform in a specific way that is well established and also understood as good, with giving voice to boy toys and not going above, the already accepted norms, giving voice to the girls.
Exactly.
So maybe that's what.
Do you remember that yesterday when we spoke about attitudes and the role, the function of attitudes, we found that one which also said if we are within the group, we know what is acceptable. So if you want to be prized or punished, we know the reaction that what would be. So Tushinka, this is a very excellent observation of the situation. Any other comment? Ksenia, sorry, go ahead.
No, it's okay. I wanted to say I know a couple of young parents who are, open-minded and are educated on these cultural and social somehow wired norms that pink is for girls, blue is for boys, and etc. And they tried to combat that with some neutral toys or neutral colors, and they faced a lot of social stigma from their parents, from their friends, from kindergarten teachers, from everyone, like, why are you doing that? Girls are girls, boys are boys, they should be in blue, this should be in pink. So even if you try to be open-minded and don't categorize children in some sort of a box, usually you will face some judgment from society, because that's how it's rooted in our brain that this should be the way it is, and that's the only way.
Exactly. Thank you so much for sharing this experience of yours. It's interesting, yeah. And for me, it was important that you see this video to understand that from the perspective that we are really babies, we are starting to gather information and to learn from adults, which will affect consciously or subconsciously how we behave. And it's extremely important when we speak about judging. And you know that the family judgments are all, and you had this introduction with Professor Marinkovic, just to show that for such a long time, there was a presumption that judges, those who decide about a certain request, but particularly judges, that they are knowledgeable and neutral. Neutrality is all about being a judge. So you have two sides, whether in criminal procedure it is prosecutor and the state against the individuals, or you have two parties in civil matters, and then you have to wait according to the facts of the case. And for such a long time, we thought, okay, judges are knowledgeable, they all graduated from the law faculty, they know how to apply the law, and they are neutral. But basically, this subconscious, particularly, and those stereotypes and prejudices that we have towards certain issues, and especially towards certain circumstances and people, it, as a result, and this is what was showed, was leading to erroneous decisions. So the judges erred in deciding, and it also affected life of many. So this is why this course was introduced, to show you exactly how it was done in practice. Una.
And that we can see from the video very clearly that kids can also will play with girls and boys toys, no matter what it is or the truck or
absolutely.
But I think parents very well know that, and they discourage the kids from playing with toys from different gender, I don't know how to call it, but because maybe they want to protect them in the future from judging based on prejudice and stuff like that. And I don't want my kids to play with Barbies. I know that he will play with Barbies if he keeps them on, but I don't want my kids to play with Barbies because that means he's a family, he's going to be gay. So
that's also, thank you so much for raising that. Yeah, it was also visible that both kids, they played with every single toy that was given to them, and they were also discouraged to play with other toys because they will pull, drag those toys, give to children in the arms. So basically, they will not have a chance to play with others. But there are different reasons why these volunteers in this specific situation did, and why parents also discouraged their kids. But it also happened, for example, to me when my boy, he was like 5, and at that time orange was his favorite color. And then we went to the river, so we'd be walking by, and then someone was selling popcorns. But the guy who was selling popcorns, he also had some toys. And there were some toys of 3 color, one was pink, another was green, and of course the third one was orange. So my boy, he wanted orange thing. And then I said, okay, and I paid. And the guy who was selling, the seller, he didn't look at me. He looked directly to my boy, saying, but boy, you should play with green. You should really take the green. And then my boy, he turned into me and said, but mom, I really want orange. And I said, we will take orange to the seller. But he pushed further and he said, but boy, boys are playing with green, so I'll give you for free. Please just take green. So he was upset with me as a parent for allowing him to go with orange. And even orange is like the Netherlands is using orange as a national color. So it can be also neutral. But he was annoyed. And that was the situation when I was also annoyed because we said orange. So, and I put the money, literally took that orange toy, and we left. But I know that he was also surprised as a kid, like what's going on. So of course, these are the reactions to that. And this is basically why we dedicated a lot of time yesterday talking about exactly stereotypes and prejudices and what causes discrimination. And you will see when we continue discussing, especially about the cases, how it is relevant. So before we go and talk about the CEDAW, I just want to finish. I didn't tell you anything about CEDAW yesterday. I'm so sorry. This presentation is really, computer is crazy, but I really hope that it's becoming better. Okay, so I will. Sorry. Yesterday was everything was well. I was just surprised that it stays as such. Okay, so I will not talk that much about the CEDAW because we will return to CEDAW specifically for this class. I just want to give you let's say, overview of other international documents which are relevant when we speak about gender equality. And you remember that yesterday, when I spoke about different forms of discrimination, I told you that they derive from the EU documents, from EU secondary legislation. We have many documents which are relevant in the EU, but I refer now to the EU Charter of Fundamental Rights, which is the main document. It's a part of Lisbon Treaty. And in Article 20, this document proclaims equality of law, but it also has several provisions which deals with some specific issues, including gender equality. So Article 23 requires equality between men and women. Here you can also see a non-discrimination clause, which is Article 21. We also have 22, cultural, religious, and linguistic diversity, meaning that minority rights are also very much respected, but not now we can talk about different minority groups, but here we see a classic ones, so those who are ethnical, religious, or language minorities. We also have children, specifically protected in Article 24, in 25, elderly, and then in 26, persons with disability. So these are the groups which are in the focus of the EU legislation, because we also have the directives which then relate to the different aspects of these groups. We also have religious minorities specifically recognized, but also have sexual minorities. They are also recognized not in a broader general term, but in relation to certain aspects. And we will talk about some of them when we will discuss certain cases. European Convention on Human Rights, I don't know if Professor Marinkovic mentioned something at his first class, but you will also, next time, you will have a jurisprudence of the European Court of Human Rights for this course. So you will deal more about the European Convention on Human Rights and jurisprudence of the court. Now, just to tell you that we have two very important provisions which are enshrined in the convention itself. The first one is Article 14 of the convention, and it's important because it also, as you can see, recognizes several grounds for discrimination: sex, race, color, language, religion, political or other opinion, national or social origin, association with a national minority, property birth, or other status. So what does it mean? This is not a closed provision, which means that also some other grounds can be recognized in practice. And this is what is happening by the European Court of Human Rights. For example, sexual minorities, people with disabilities, they're all also protected. And also this wording that we discussed yesterday, sex. In the legislation, in the jurisprudence, of the European Court, we see that sex is also broadly defined, and also gender is recognized by other statutes in some cases. Why do we have two provisions? Article 14 is an auxiliary right, how we call it. So it means that it doesn't have a legal standing itself. It means that Article 14 can be invoked only in a case when rights and freedoms guaranteed by the European Convention of Human Rights are violated. So what does it mean? That someone can claim discrimination only in relation to the right that is protected. For example, the right to property or freedom of thought, freedom of expression, freedom of movement. So these are the rights and freedoms which are guaranteed by the European Convention. And basically, Article 14 wants to protect that those rights which are guaranteed someone cannot be discriminated in accordance with those rights. However, I don't know how much you are familiar with the European Convention. This is a document that guarantees rights of how we call them first generation of human rights, which means civil and political rights. The right to education is the only one who comes from a broader scope or coming from a so-called secondary generation of human rights. This is why Protocol 12 was introduced later on. And Article 1 of Protocol 12 gives an autonomous standing of these rights. What does it mean? It means that I can invoke Article 1 of the Protocol 12 in relation to any situation when I was discriminated, even in accordance with rights and freedoms, which can be like from social protection or some, for example, employment rights, which are not guaranteed by the Convention. So this is why it's important to always take into account that we have these two provisions. But of course, as Article 14 was introduced with the Convention, which was in 1950, the Convention itself entered into force in 53. So basically, we have a document which is 70 years old already, and majority of cases that were developed by the court are coming by invoking Article 14. But we still have more and more significant cases where states or state parties invoked Article 1 of the Protocol 12. So this is why it's really important to understand this difference. And then in the Council of Europe, we also have some, let's say, specialized conventions when we speak about gender equality per se. We have two important documents. One is the so-called very famous Istanbul Convention, and I'm pretty sure that you are or at least familiar with this document. We also mentioned some of the provisions of this document in our previous course. So basically, Istanbul Convention deals with gender-based violence. And we also have another document which is extremely important, and this is a Convention on trafficking against the trafficking in human beings. But of course, as we know that trafficking pretty much affects women and girls, this is also a very important document. So again, the first one is, if you remember yesterday when we spoke about CEDAW, we said asymmetrical protection. So giving protection only to women and girls. And this second document basically gives also standing to men and boys if they are victims of human trafficking. But as we said, dominantly victims are women, especially when we speak about sexual exploitation. When we speak about, let's say, exploitation in relation to the work, then of course we also have more and more men and boys who are the victims. why we mention gender-based violence, it is especially important to understand that sometimes we have that very, I would say, artificial division between violence, gender violence, and gender-based discrimination. But what we understand is that gender discrimination is the root cause of gender-based violence. If you do not have these stereotypes and prejudices in the society, then gender-based violence will be minimal. It will not be existent. But basically, breaking these traditional norms, either in a family or replicating those traditional norms, they lead to gender-based violence and inaction of state authorities when gender-based violence appears. How we can define gender-based violence? You remember that yesterday I told you that we do not have so many definitions in international law per se, but with gender-based violence, we again refer to this Istanbul Convention as a specialized document, and European Court of Human Rights, for example, very much relates on the provisions of this convention. So it is very simply said, violence that is directed against a woman because she is a woman or that affects women disproportionately. So very, let's say, short, but at the same time understandable definition of what gender-based violence is. Specific form of gender-based violence is domestic violence. And why domestic violence? Because for such a long time, what was happening in a private sphere was outside of the notion of the state. And state was not interfered in privacy of someone's home. And you remember that one of the first rights which developed in human rights scheme was also the right to privacy. So what was private and what was public, it was a very clear distinction. However, that was also the reason why in many cases state authorities did not react in a case of domestic violence, which sometimes led to very serious harms and consequences, including the death of a person who was exposed to that violence. And by the European Court of Human Rights, we have one very famous so-called Opus versus Turkey case from 2009. Now we have many other cases, and I'm pretty sure that you will do some of these cases with Professor Marinkovic next time. But let's just see what were the main finding of the European Court in this case, because it was a case of domestic violence. The violence was reported to the police. Police was inactive, and the person who was exposed to domestic violence had very many consequences, including the death at the end. So what the court found? Bearing in mind its finding about that the general and discriminatory judicial passivity in Turkey, albeit unintentional, mainly affected women, the court considers that the violence suffered by the applicant and her mother may be regarded as gender-based violence, which is a form of discrimination against women. Despite the reforms carried out by the government in recent years, the overall unresponsiveness of the judicial system and impunity enjoyed by the aggressors, as found in the instant case, indicated that there was insufficient commitment to take appropriate action to address domestic violence. So what we've seen here is basically that we had repeated cases of violence, that the police was very silent when the applicants also submitted then that case to the prosecutor's office. The prosecutor's office dismissed the cases. When judges decided about the police inactivity, they didn't find that police was responsible for that. And basically, this is what the court found. And this is why this case also opened the door about the discussion of gender stereotypes also by public officers, and especially those deciding about the cases.
Sorry, Professor. I remembered now we had an assignment from Professor Bojan Spajic, and actually we analyzed this case from different feminist perspectives.
So of the case.
Yeah.
Good. It's good that you did it because at the same time, this case really this is a landmark case of the European Court of Human Rights, opening the door. And of course, now we have some standards which are further developed by the court. But it was the first time that basically the court said, yeah, but it was judicial impassivity. the judiciary was responsible for not taking also action. This is why it also generated course like this one. So the influence of this decision is really very widespread. Una.
At least that conversation about putting defense in.
Also, one of the cases, it was then repeated in many other cases, subsequent cases. Unfortunately, we have many on gender-based violence also decided by the court. You will discuss it with Professor Marinkovic. But yes, that was. But there is also a very tricky, let's say, discussion among also activists. Do we need a specific legislation? And what we know in Serbia is that what we have at the moment is also enough to decide more seriously cases of which also has, as a consequence, have death. Sorry. But unfortunately, so we will not change the perspective of deciding if we also include specific criminal act. And this is what the court basically said here. We can have a very good legislation, but the implementation is lacking. Then we really need to tackle what's the reason behind. But here, this case is also important, not only from the perspective of this class. It is important also to say that European Court of Human Rights clearly said discrimination, domestic violence is a form of discrimination. It is also discrimination against women per se. And finally, just to finish with multiple and intersecting discrimination, you remember that we mentioned this term on several occasions, but it is important to understand that sometimes the identity of certain person can bring that person into even harder position, because there are many grounds for discrimination which can be present at a certain case. So this is why it is important also to have that layer to take that layer into account, and also to analyze by judiciary also these aspects, and not only that, but to also impose harsher sentence if someone is exposed to multiple or intersecting discrimination. What does it mean? It means that you have different grounds. For example, you can be a woman and you can be a migrant woman. Yeah? And sometimes being a migrant woman, it is, for example, hard because you are taken in a specific position. Of course, for example, if you are a single woman, migrant woman, then you will have more harsh situation than, for example, a migrant man who is not, for example, a parent and not a single parent, because he will be able to get job more easily than someone who is like a single mom and who is of other ethical background. But it really, what's the difference between multiple and intersecting discrimination is that in some specific situation, being having all this identity brings that person into a harder position than when we have these multiple grounds, where, for example, only one ground at some specific time can be important for the case. And it is important, for example, when we have this case of migrant woman who is a single, then we have intersecting discrimination. And this is why it's important to understand that difference. And here we have some cases, but I will not now discuss those cases. I would like now to refer to CEDAW, to our, I just hope that it works. Yes, okay. So I don't know how much you know about the convention. Did you have a chance to read about this document? I'm pretty sure that it was also mentioned for some previous courses. Let me here, but sometimes it's freezing for some reason. Thanks. Okay. Okay, so what is CEDAW? don't know what's going on with this computer today, really. Okay, can you who are online, can you see the presentation?
We can see it, yes.
Okay, great. So now we speak about the universal document which was adopted under the UN auspices. The convention, and here you can see some regional photo from the time when it was adopted, and what you can see are all men sitting and discussing the convention which deals with elimination of and there is some woman, yeah. But those dominant part of the photo are men, yeah. But this is the document which was really long waited. It was adopted by the General Assembly of the United Nations. And as we usually speak, that Universal Declaration of Human Rights and two covenants, one on civil and political rights and another one on economic, social, and cultural rights are Bill of Human Rights. When we speak about CEDAW, we say this is a Bill of Women's Rights. So the most important document that we have. You seen yesterday two provisions of this convention, if you remember. Article 1, which defines discrimination, and Article 5, which deals with basically tackling gender stereotypes. And importance of this document is that it tackles discrimination of women and girls. So it is also the scope is very wide because it also applies to all spheres of life, whether public or private. I'm so sorry. I just need some water. Pardon me. And what is important is that this document is legally binding for states who accept it. And today it's one of the most widespread international documents that we have. The one which is more, let's say, recognized and accepted by states is the Convention on the Rights of the Child. And this is the second one. So states agreed that this convention is extremely important and that this document should be adopted. The root or the origin of this convention is based on Charter of the United Nations, which also proclaims equality of men and women. Then it is also based on Universal Declaration of Human Rights or its text. And also there are some other provisions which were included before, especially these two covenants, which also recognizes sex as a ground for discrimination. So covenant on civil and political rights, and especially Article 26 of this document, and also International Covenant on Economic, Social, and Cultural Rights. But what we know is that we had a global women's movement fighting for equality, for rights to vote, and many other rights which now we take for granted, but which were not recognized for women at a time. So that was, let's say, a driving force to introduce this convention. It was adopted in 1979. So now it's a pretty, again, old document compared to some others, but it's also still valuable document. It entered into force 2 years later. So for those who know how much time do we need to have entry into force of a document, we know that it's usually a much longer time. Here it was a very short period of time, and convention was accepted today. It is accepted today by almost 190 states. As I said, a very huge number. Is there anyone who knows how many members of the United Nations we have today? 197. Maybe a little bit less than that.
69. Oh, 79.
Okay, now the elicitation, who gives more and less, but it is 193. So basically, only four members are not. They did not ratify this convention. So it's a very, very widely accepted. What is the objective of this document? First of all, is to eliminate discrimination. So this is the main aim of the convention, to combat gender discrimination. And you remember that yesterday we spoke about these two theories on equality. That equality can be considered to be formal equality and substantive equality. The whole document basically is based on substantive equality or achieving something which is sometimes called de facto equality, equality in practice, in other words. What this address? First of all, legal discrimination, meaning discrimination which is, of course, which scope goes within the definition and the elements of definition that we discussed. Then cultural and social norms. So we said one cannot be achieved without social and cultural norms. Structural inequalities. Is there anyone who can explain to me what is considered by structural inequalities? Any guess? Structural inequalities.
I have a guess, but I'm not sure.
No, please, just we are discussing doesn't.
I think I'm not. I have a structural inequalities with like it's some kind of a legal measure that I can't really explain, but like a legal measure like laws or something. Or like on the workplaces or something.
Good, Una.
What I'm like is like systematic discrimination. Like that it's rooted in the system, not just social norms, also that, but also in the system, the whole system.
Good. Some other thoughts, online folks?
Well, maybe inequalities in labor field or in the schools, in public institutions.
So it's more or less what Una said, like that we have.
Yes, I didn't hear her. Sorry.
No, that's okay. I mean, she didn't say exactly what you said, but. Okay. Okay. Any other thoughts? Okay. Good.
I would say maybe that patriarchy itself is destructive. So it's not the particular institution that is giving the structural inequality, but the patriarchy itself in the society we live in is as the whole society is constructed, not a particular institution. It's like a pyramid. So the institutions are here somewhere, and here are over everything to the patriarchy, which is the structural inequality.
Very good. Lushenka?
I feel like that is connected to the social cultural norms, but deeply embedded in society. And somehow, when I think about structural inequalities, I have in mind rural women, and rural area is structurally for the system, not that important as the urban one, aside from the agriculture. If you have just a rural domestic cohabitation, one house, it maybe your life is not seen as valuable as the one who is, I don't know. I mean,
You're all right, because you have a sense of what's structural inequality. It is embedded in what you remember in patriarchy, absolutely. And you remember what we said yesterday in the power of those who are ruling. because those who are in power, they don't want to give that power to someone else. They don't want to share that power with someone. So basically, the whole idea, the objective of CEDAW Convention is to tackle those situations and to break them. So how we can do it? One of the way, and we will see it later, is through specific measures. For example, quota system. So we'll come to that. We'll discuss it more. Dušanka.
Wouldn't that be the Article 5 saying you need to see family as the right to both parents?
Absolutely, but it's more than family, because here we are breaking all structural inequalities. For example, this is why several years ago the European Union introduced directive on women's on board. So we know that we don't have much women in managerial positions. So we need to break that structural inequality which exists in the society. How it exists? It exists if, for example, those who are electing those who are in the board, they don't want women because of all these, let's say, presumptions that we discussed yesterday that are attached to femininity. Emotional, sensitive, not trustworthy, and so on and so forth. Yeah. So this is a structural inequality. So we can introduce, for example, provisions saying we can have 50% of women in the board and 50% of men in the board. This is the ideal. But if we do not tackle those structural inequalities, we will never attain that parity. Let's say. So that's structural inequality. So you want to identify all these structural inequalities which exist and to introduce measures to tackle them. But they are all over, as Matthew said, and they are embedded in patriarchy. So this is a very good short explanation of structural inequality. And of course, one of the main goals is a full participation of women in all spheres of life. So we know that we have like 51% of women and 49% of men as a total population. So we want to have that parity in all spheres of public and private life. I will not go into the definition because I think that yesterday we discussed a lot. We will just see very briefly at another slide, again, what are the elements of discrimination, just to repeat it. But when we speak about domains, you remember that we said political, economic, social, cultural, civil, or any other field. So why we name these 5? Because they're the most common denominator in which we have and see gender inequality. But at the same time, they can also be another field. And for example, for family judgments, we speak about the judiciary. So the judiciary should be also there. But with any other field, it is also protected by the convention. What are the state obligations? It is extremely important that to understand that when we speak about human rights, and of course this convention is a part of human rights scheme, one instrument, very important instrument dealing with human rights, state always have a threefold responsibility. First one is to protect. So it means to adopt laws which provides or acknowledges that everyone is equal before the law. So what we discussed yesterday, or equality in all areas of life that we can imagine, and to protect everyone from discrimination. For example, when we speak about gender-based discrimination, that would be exactly the case. So the first one is to protect. Then the second one would be, and it's very important, which is usually neglected when we speak about human rights, is this is to respect, then to protect. The protect would be the second case. And the third one would be to fulfill. What is to fulfill human rights? What do you think? So to protect, to respect, to protect, and to fulfill. To implement it, exactly. How, for example, we are implementing? For example, if just to give you an example, to respect means take into account the right to education. The right to education to respect means to proclaim by the law and by law that everyone has the right to education.
To respect.
This is to respect, exactly. Then to protect would be to protect everyone whose rights are violated, for example, and especially if you, for example, have in some cases violence in school, or someone is discriminated because someone cannot be employed, for example. So everyone which goes, but we speak now the right to education, so we will not take employment. We will speak about the peers, for example, violence or violence of I don't know, teacher against a student, pupil.
To respect, also to refrain.
It's also to refrain. Absolutely, absolutely. It's a very important aspect of it. What would be to fulfill? For example, when we take into account the right to education.
So, for example, implement practice.
Okay, but this is why I wanted to give you this example, just to be sure that we understand what implementation means.
Then in change the laws when new obligations are.
And this is the right to respect. Yeah, so this is right to respect. So to proclaim that everyone, what's the standard? Yeah.
Studies are mostly free, and like university is free, but it is also like you have to move to university. So in case your parents, for example, normally the parents have to move to Germany, they have to give you money, but then you can live until you have until you're educated. But some parents are not capable of doing this, so we have a law in Germany that provides for children also the option to go to studies so they can apply for money to come out of, and they get money from the state, so they can pay during their studies, so they don't have to work in their studies.
This is a very good example. This is exactly what fulfill means. So fulfill is no, it's not, because the fulfill means more positive measures. It means what we are doing in order to allow someone to really enjoy the right to education. So it means, for example, to open schools, to have enough schools, to have the regional diversity. Because if you have schools which are oriented towards the main cities and then in rural areas there are no schools, or there are less schools, then again we need to take additional measures, which is, for example, transportation and free transportation, or getting subsidizes, as you mentioned. That's an excellent example. Or, for example, I don't know, to have enough teaching methods at school, to have textbooks. If we, for example, acknowledge that minorities have the right to be educated on their own language, then also to publish textbooks, to employ teachers who are capable of speaking on that language. So it means fulfill. So fulfill is basically, although all three are equally important, it is also important to understand that the state's obligation is it's a very basically very, I don't know which word to use, but very, I cannot say widespread, but in a means comprehensive. So comprehensive is a better word here. And we have to fulfill all these obligations that state has. And this threefold obligation is very much present when we speak about the CEDAW. And what we see here is that also the scope of application is very widespread. So we speak about private life, and you will see that some provisions of the convention deals with marriage, with family status, for example. And so this is why private sphere is important. Then we have a public sphere as well, because the primary, let's say, aim of this convention is to regulate the public sphere, and then also a cultural sphere. And this is what we already said is Article 5, very famous Article 5, which requires modification cultural and social patterns. Here, for example, we have some of the obligations which clearly derive from, so this is what I said, this threefold obligation is something which is derived from the theory of human rights. And these obligations that you see here are those who derive from the language of the convention itself. First of all, to transpose what is said in the convention into the national legislation. And why it is now complicated, as some of you are not lawyers, this means what is usually the relationship between the international law and national law itself. So we will not go into that, but it is why it is important to transpose, to translate those international obligations into the national system itself. Then, of course, and this is what we see now in international arena so much, that, for example, we fight in some countries, we fight for introducing laws which proclaims gender equality, but now there are many countries that want to revoke this legislation, and they are now again introducing legislation which is basically discriminatory in certain areas of life. We see that in many areas, for example, and mostly there is a huge debate about sex and gender equality, and also diminishing or deleting the term gender, which also minimizes the scope of that those provisions. And at the same time, we also see that states want to, for example, which is a very interesting dynamic that we didn't have in international fora so far, that states want to basically they decide to leave, to revoke the international conventions. It's not happening with CEDAW at the moment, but it is happening in Europe with Istanbul Convention, for example. We know that Turkey withdrew from the convention, and I don't know how much you are familiar with Poland, for example. It's a huge debate now that Poland do the same. Also, there is a rhetoric in many other European countries. It was in Croatia, even in Serbia, we had that discussion. I don't know if in Germany you have discussion of that kind. In Hungary as well. So in many European countries, and mostly Eastern European countries, it's a very present moment of withdrawing, or at least discussion on why to withdraw from the convention. Then another I'm sorry, Dushka, you wanted to ask something.
I don't know if that's a question, but it can be formed as a question, because I just cannot understand. Even when the CEDAW was being written, they used terms that they thought about gender. So they thought about gender norms, gender stereotypes in the terms of sex. And I just cannot wrap my mind around why it is such a big deal of not wanting a term gender when you are describing what you before thought was sex.
Because for states, it's acceptable to understand that there are social norms which are shaping the life of men and women. So for them, it is acceptable. But you remember yesterday that I told you that we have several grounds for discrimination, gender expression, so the identity, everything that we discussed. And basically, more and more, before, we had a very clear distinction that gender includes only these social norms which are related to men and women. But now we speak about all this diversity of identities, about those who are even neutral now. Yeah. And for many states, they believe that it is breaking the traditional norms in a society, and they are basing their arguments exactly on that.
Actually, gender is not belonging to men and women, but to other.
To all diverse groups as well. And this is why they oppose it. And usually they say, because in many countries, the constitution is like in Serbia and like Germany, the constitution is the highest legal document, and then international law. And many states claim that the constitution itself uses either the term sex, or if it's in very rare situations, use also the term gender, that it's very narrowly construed, and that this is broader, so that basically it is unconstitutional. So it's the same debate that they have in Poland and in Turkey. They had exactly the same debates.
Being critical because everything was fine, but this is part of it.
Because states, they want to, in a way, they don't see a problem to tackle discrimination of women and girls per se, but they don't want to tackle or to give so much. So you see, the scope of this convention is extremely broad. So they don't want to add to that LGBTQI plus people as well. So that's
the fear of the unknown. Yeah. I have to understand all those different gender identities and gender orientation to understand and I don't want to do that. And it's easier.
And also, it's breaking patriarchy, on which the societies are based. So this is why that there is such a great opposition.
We don't know any different social construct system than patriarchy. And like if we don't have it, then we have something that we don't know. And it's also like a fear of unknown.
No, absolutely. It is a fear of unknown. It's a very good comment. But that's exactly what's going on. So then we see it on such a huge scale that now even women's organizations, women human rights defenders, we really see so many countries such a huge attack against the feminist movements and also gender equality per se. So this is why CEDAW is more important than ever. But states are still not opposing CEDAW so much as, for example, Istanbul Convention. And we also have other two additional regional documents. We have African the document and instrument, and also a Latin American instrument. Para de Bellum, how they call it, which also deals with gender violence, and the same process is over there. But I would say that Europe is now really reaching the high peak with these anti-gender movements. This gender backlash is really very, very present. Another element or obligation of states, which is extremely important, are effective remedies. So when your rights are violated, you really need to have an effective remedy. And in order to have effective remedy, you really need to have access to justice. This is the first step. And then when you have access to justice, also we need to deal with these stereotypes by judges themselves in order to get an effective remedy. So see how it is complicated and why basically we are tackling this area specifically. Access to justice can be limited in many ways, and you also have many researches showing what's going on in many countries. First of all, for example, if you have the courts jurisdictions in countries, and then you have courts who are far from rural areas. For some rural women to pay even for transportation to come to the court to submit a complaint is already too much. It's almost not possible. Many women, especially those older women living in rural areas, they're uneducated, so they don't know how to use this right. Then another problem is that they don't have means to fight against discrimination. So this is why free legal aid is important. So there are so many needs to be fulfilled. So this is exactly when we speak about access to justice, that's part of a state obligation to fulfill these rights. And we will see what does it mean to submit periodic reports to the UN. When it comes to the structure itself, this document is pretty, it is not so, let's say, long, but at the same time, it also has 30 articles. We have, as you can see, the first 5 let's say, provisions of this document are those which give us definitions and principles on which the convention is based. So I call it definition of discrimination. Then we have several articles which deals with political and public life. Political life, which is extremely important because if women are not in a political arena, then they will not they cannot do the advocacy. on the reform of legislation. They cannot decide of those initiatives, so it's really important that they're present in public and political life. Then the next part of the convention deals with education, employment, and health. Another one with equality before the law and family life as a very important aspect. And then we have many provisions which deals with monitoring mechanisms. It means that this convention, as some other conventions under the UN auspices, they have a treaty body or a committee, a CEDAW committee, so-called, which basically developed these standards further. Definition of discrimination, you remember that we did it yesterday with Article 1. I will just remind you that elements are distinction, exclusion, or restriction. So acts or failures, which basically, as a consequence, have distinction, exclusion, or restriction. That restriction, distinction, or exclusion is based on sex. What is the consequence is the minimizing enjoyment of human rights or restricting those rights. Applies, as we said several times, to public and private spheres, and also covers something that we did last time, yesterday. This is direct and indirect discrimination. What are the key substantive areas which are covered? So now you've seen how the structure is developed within the convention itself, but it deals with political participation, with education, employment, healthcare, marriage and family relations, nationality and citizenship. Very important, because for women, and especially women living in some specific parts of the world, it affects their enjoyment of their rights, if they are single, if they are married, if they are divorced. So their status pretty much affects their rights. Then you remember that Dushenka mentioned rural women. It is important to understand that this convention recognizes all women, but we have specific provisions dealing with rural women. So at the time that the convention was adopted, it was recognized that for women living in rural areas, it is important to put a focus, because otherwise they will not be able to enjoy these rights that are here. For example, employment, education, healthcare, so on and so forth. And also trafficking and exploitation in Article 6 is also prohibited explicitly. Article 4 recognizes special measures. What are special measures? You remember that yesterday we discussed that we cannot break these structural inequalities if we do not introduce some special measures which will give either preference or maybe even a quota system for women. And is there anyone who would like to tell me in which area of public life are usually quota system introduced for women? Political participation, exactly. In many countries we have, excuse me?
Yeah, I said that in parliaments, in political participation.
Mm-hmm. Very good, Jelena. So in political life, in any other life, sphere of life, Matthew?
It's Martin, by the way.
Martin, but why you didn't tell me? No, it's not by the way. It's a very important part of your identity, Martin. Sorry.
You have gender quotas in Serbia?
Yes. You don't have a gender. Okay, but in many countries, quota system exists. How many women do you have in your parliament?
I think 30%,
35. 35.
Depends on the party. The conservative and right-wing parties, they have less. The more liberal and more leftist party have more. I think maybe they have quotas, I'm not quite sure, but they have no quota by law.
You don't have a quota by law. That is interesting. What do you think about the quota system in political life? I'm first of all, I'm asking Martin, but of course, I also I want to hear the opinion of others.
I think quotas are not that effective. At least I think it's targeting the wrong things, because I would say the issue is not that we have not enough women in ruling class and ruling class jobs. That's not the issue. That's not the women who suffer, who can go to parliament, who CEO. That's not the issue. The working class, like the poorer people, that's the issue we should tackle, and not quotas which benefit some rich people.
Why do you think that quota system benefits rich people?
Because quotas are mostly used for things like parliaments, for high-paying jobs, CEO positions, board memberships. It's not. It's of course it's a form of feminism and trying to include women in their positions as well. But I think that their focus is totally wrong. So I'm not the biggest fan.
Okay. Some other opinions? Mona?
Yeah, I think they're just a part of the solution. Because we now have a lot of, for example, in Serbia, we have a lot of women in parliament, but the situation in other branches too, but the situation is not the best. And I know, for example, I was talking to an NGO, feminist NGO, who they were doing how do they say, seminars or trainings for political parties to feminism.
Mm-hmm.
And they didn't want to do that training with the Serbian Progressive Party, even though they have, I think, the most women in their party, and they're the biggest party. And they are, of course, not educated in feminism and tools of feminism, etc. And also, there's the other side of the coin, of course, the political parties who do have a lot of women who do that, have also quotas within their system, and who, of course, participate in trainings and are very local on feminism. They leave the gender topics and women topics to the women in the party. And you can see on conferences that they hold on the a lot of campaigns on women's issues. You can see that the women from the party on that events, the males are invisible. So I think you have to have both sides. The both are good, but they are not
enough. I mean, of course, I mean, no one is saying that whether they're enough or not, but just is it good to introduce a quota system or not? Are you interested in, let's say, the history of feminism in when we speak about the political life in the region itself, not only in Serbia, but in the region and then in Serbia? Because I have a perfect person for you to deliver a lecture. So we will, in the second semester, you will have consultations for courses, because you don't have enough number of persons who assign for certain courses. There would be one, I think, on criminal law. I'm not sure. Where majority of you assigned. And we will once again discuss if anyone wants maybe to, in order to listen to that course, wants to change the course. I'll talk to you at the end of this semester. But then we will have more opportunities to bring some special guests for you, some special guest lectures. And Biljana Maletin is really amazing, and she knows so much about the political life. I don't know how long you will stay in Belgrade. Only this semester. Okay, so let's see what we can do. In any case, if you organize something, we can invite you online to join us. But yeah, the quota system is very interesting. I will not give you my opinion on that. But quota system is basically also introduced to break these structural inequalities. And what you see in countries which introduce quota system is that when you have quota system, you will have more women, let's say, in a shorter period of time, you will have more women involved in a political life, in a political sense. And of course, that's there. We need to, as Una said, many other measures to support the participation of women in political life. But at the same time, now for us, it's normal to see. I mean, we usually see the empty National Assembly, or just those people who are like leading, have a leading role in their political parties, which are in the parliament. At the same time, like 20 years ago, the structure of the parliament was absolutely different. And then today, and I don't know if you remember, when we introduced the quota system, it was quota system to have that parties need to have each third candidate on the list that is a woman. But then when we get the elections, then each party could replace that woman with another candidate who was like fourth of the list. And this is what happened. And then the new law was introduced saying, no. I mean, every third woman needs to be on the list. And if she is on the list, she cannot be. Reported him. He said to his male colleagues, yeah, we know that they are incapable, but what we can do, we have to. I mean, we have to pretend like that we like women in the parliament, and this is important for our integrations. Anyway, of course, but at the same time, we really have more and more women involved in political life, and this is a very good consequence of it. We spoke so much about cultural and social change, Article 5, and I will not repeat it once again. I just wanted that you have it on this slide for some exercises that we will do later on during the course. It is just important that this is really perceived as one of the most transformative provisions in the convention, especially taking into account that the convention was adopted in 1979. I still remind you that at a time, social norms, I mean, we are all aware, but many were opposing that we have this kind of provision in the document, which is a legal document itself. Here we see the members of the committee. So different conventions, they have different numbers of committees. This one is has really the biggest number of members, 23. And what you can see on this list, this is a current composition. We have one male who is a member of the committee. They are dominantly women sitting in this treaty body. And what we know is that it is based in Geneva as other treaty bodies. The most important obligation that state has when it speaks about CEDAW is a state reporting procedure, which means that states, when they ratify the convention, they within the year submit a report, which is called initial report. And then every fourth year, state is obliged to submit new reports. So what is the part of this reporting system? This is, first of all, to go provision by provision, to say where are the changes in the legislation, but also in practice, to give some statistics, to give examples of state practice, and especially court practice, which is important because like 10 years ago, it was not so much included in the reporting itself, but now committee more and more requires states to tell us, okay, do we have an effective implementation of this, an effective remedy in cases of violation? And basically, the committee reviews the report. It is important that every single state is always providing a report which is better than what is the situation in reality. So this is why either independent institutions in that country or NGOs, they submit something which is called alternative or shadow report. Shadow report meaning that they sometimes even they specify specific areas in which state didn't do much or where there is a problem. Then the delegation of the state is invited to Geneva to defend, in a way, the reports, to have a constructive dialogue with members of the committee. And then finally, committee is issuing concluding observations. So what they concluded about the report, what are the good sides in that period, what was improved, where is necessary to work more, and then a specific part of that state procedure is our recommendations. So what should be done in the next reporting period. Another important tool is our general recommendations. Today we had 40 general recommendations. The one that was adopted last year, 2 years ago in 2024. This one is exactly on public and political life of women and girls, and I recommend you to read this one. Of course, many general recommendations are important. They are dealing with absolutely different aspects. For example, Convention does not mention explicitly gender discrimination per se as a wording in the Convention, but there are several general recommendations which deal with gender-based discrimination. It is general recommendation number 12, 19, which is like a very, very famous, and then 35, which replaced this number 19, and it's a very comprehensive document.
This recommendation, I can send them the recommendation, but is it binding? As in,
you have the last sentence on the slide saying that that it is important that the second and the last sentence are the most important when we speak about general recommendations. So the first one says, provide authoritative interpretation of the convention. So we have experts, not independent experts, not political members sitting in this committee. They're experts which provide interpretation of the scope of certain provisions of the convention. So it means that there is authority within this document itself, but it's not binding. And this is why it's called recommendation. But it means that it really gives us standards which states should, in a way, follow, that can object, but they have to have a very thorough reason why they refuse to read that general recommendation in that way. And there are really many other important general recommendations. Some of them specifically deal with certain groups of women. For example, again, rural women, women with disabilities, asylum seekers, and migrant women, and so on and so forth. A little break. Oh my God, I'm so sorry. Why you didn't say? Okay, is 10 minutes enough? Okay, we'll continue at 22:08. Oh my God. Okay. Why didn't say? No, it's. It sounds nice. Okay, folks, I hope that we can continue.
Yes.
Just to give you a brief also history that apart from the convention, we also have optional protocol, which was adopted in 1999. So what is optional protocol? This is additional convention, which was adopted to, in a way, support to extend this convention. And optional protocol did not bring any new substantive law, but it also brought two additional mechanisms for monitoring of state obligations. The one is extremely important, and this is something that would be the core of family judgment course, and this is individual complainant procedure. So when an individual who believes to be a victim of gender discrimination submits complaint to CEDAW on decision, and also something which is called inquiry procedure. Inquiry procedure exists only in a case when we have systemic and massive violations, grave violations of women's rights. Individual communication can be submitted by anyone if that individual claims that violation happened within the jurisdiction of a state that ratified the convention and this optional protocol. The sub-optional protocol is giving standing to recognize the jurisdiction in this specific case. It's just important, very briefly, for you to know this, but for the course, when we speak further about substantive issue that was decided by the committee, CEDAW committee, that will be the core of our discussion. What is important is that before you go to CEDAW, you need to exhaust domestic remedies. What does it mean? It means that in all cases you will see the victim trying to get access to justice and effective remedy in that jurisdiction. But when, and this is why it is interesting, the court did not basically recognize that a person was a victim of discrimination, or it was not recognized in a proper way in accordance with the convention, then that person can submit complaint to the CEDAW committee. Yes, we ratified. Yes, we ratified. I'm not sure about the total number, but I think that 169 states ratified this optional protocol, so a little bit less than the convention itself, but not that less in a way. So still a lot of states.
Are individual petitions, are they being used here? Because do we have practice?
We have a practice, not against Serbia concretely, because mostly for some reason, CEDAW was not used. That was one reason. Maybe not as it was not weakened that they were not so knowledgeable about the CEDAW itself, or in some cases they wanted to submit the case before the European Court of Human Rights for different reasons that we can also discuss. But when you finish with the European Court of Human Rights with Professor Marinkovic, then we'll have enough time to discuss the difference and why some will choose to go to the European Court preferably. What is important is that the committee is not delivering a judgment. It's delivering a decision which is called view. So our view, or whether there was a violation or no violation of convention, and also gives recommendation to a state. And it's very important that it gives a very important, thorough recommendations for the state and for an individual who submitted that communication. The decision is important because, as I spoke with your colleagues during the break, The task for this course would be either to write or rewrite the decision of the CEDAW committee or the European Court of Human Rights. So that would be one or another. We'll see. And for you, it's important to know what are the elements of a decision overview. So what are the parts of the decision? First of all, the facts which are given by the complainant. And of course, the CEDAW can always ask for additional information, but we are basing on the facts that were given by the complainant. The complaint itself, which is a very important element of the view. First part is a state party's observation on the merits. So the state will object, of course, what the individual said, and state will give some rationale, some explanation, some excuse for the practice that happened. And the second part of the complainant is the complainant comments on the state party's observation. So then the complainant has a possibility to, in a way, confront the state and to say, yeah, but it's not true. You didn't pay attention to this. You did this and that. So it's also very important. So basically, based on the facts and on the complaint, we are issuing a view, or the committee is issuing the view. Issues are, first of all, consideration of admissibility, apart from to exhaust all local remedies, domestic remedies. There are also some other requirements, but we will not deal with that. So for your exam, also the admissibility part will be dismissed. So we pretend that admissibility part is non-existent, especially as not all of you are lawyers. So it would be really not okay to give you that part. But for us, it's important consideration of the merit. So that if you get this task, then you will need to prepare a view based on these first two elements of a decision. Inquiry procedure, very briefly, is, as I said, when there is a complaint that there are systemic and grave violations of women's rights in some country, and it can include countries visit. So even the members of the committee can visit that country to see on the ground what's happening and to talk to different actors. This is confidential, and it also requires state cooperation, which sometimes is really complicated because if you have a massive human rights violations, no state will be willing to accept you on the ground and to give you that possibility to inquire what happened. And the importance of CEDAW today would be that it's central to women's rights. It's developing these rights. The scope of application through general recommendations is really immense. And it's also important that let's say, influence of CEDAW was that some states changed their constitutions. Some, they introduced new legislation and also aborted legislation, which was discriminatory. They also improved the practice in many areas. And also it is important for NGOs, for activists, for human rights defenders, which means that CEDAW is also used for advocacy, for research, and to further, in a way, generate the gender equality. So as a conclusion, so what we can say about CEDAW is that it is a cornerstone of women's rights, as it is called, that it combines different approaches, legal, but not only legal, which is extremely important for us, for lawyers, and forget about all these other tools, that it has a very effective monitoring mechanisms, so several of them, and the reporting is the one which is a requirement for every single state who is a state party to CEDAW. Then individual complaints depends on the visibility of the mechanism. Then free legal aid, which is usually provided by women's NGOs to victims. It also depends on the free, not only free legal aid, but also, as we said, advocacy, teaching, preaching about CEDAW. And it is important, especially today when we face with this gender backlash that I just mentioned. So this is why at the moment there is also, and it's good for you to know, initiative to introduce a second optional protocol to this convention, which will specifically deal with gender-based violence. So there is a tendency of certain actors in the field But there is a fear that if we adopt that optional protocol, then some states will say that they will not ratify this optional protocol, and then they can say, because we have an optional protocol, gender-based violence is not recognized by the convention, although it is already recognized in general recommendations. But for some states, they will use that as an excuse, saying, but why we need this optional protocol? If we have it, it means that we don't have, that it's not recognized as such. And you remember that we said the recommendation is not binding, but it has an authoritative importance. Is there any question to what we did so far? Elena, Alexandra, Xenia, anyone else?
No questions, Professor.
No questions, it was clear. Okay, so
Yes.
now we will return. I will leave for the next class the lecture on stereotypes because I was not aware of the time. But anyway, now we will go through the cases. Mostly I'll give you today, so I'll not give you the cases of CEDAW. We will turn to that speaking about stereotypes next time. Now I'll give you some cases, interesting cases that I know that Professor Marinkovic will not deal with you about these religious symbols. You will talk with Professor Tanasi. Let's see. Okay, Van Raalte versus the Netherlands case. Okay. So you have a brief facts of the case. So we have the applicant who is a national of the Netherlands and who had never married nor had children. He paid contributions under the general childcare benefit.
Sorry, Professor, we don't see it.
You don't see it?
No, it's blank.
It's blank. Okay, let's try let's try it again. Sorry. And please let me know if you can see it.
It's still blank.
It's still black?
Blank, white. Oh, we can see it now. Yes, it's visible.
Can you see it now?
Yes, yes.
Okay, I don't know what's going on with this computer today, but I think that it's Friday night and they want us to leave, yeah? Joking. So, okay, so I'll repeat once again. These are very brief facts of the case. The applicant is a national of the Netherlands, had never married nor had children. He paid contributions under the General Childcare Benefits Act of 1962, which provided that any person under the age of 65 was required to make payments. These payments went towards a scheme which entitled any person to gain benefits for children for whose maintenance he or she was financially responsible. Unmarried childless women over 45 years were exempt from having to make contributions. Men of the same age were not similarly exempt. What do you think about this practice?
What was the rationale? Why?
I'm asking you, Martin.
I would say.
Now I'm proudly saying your name, Martin.
Well, I would say the reasoning behind it is that men that can still get children, probably that's the reason why women are excluded because after 45, it's unlikely that they will get children, but men feel hopeful that start not able to get children.
Mm-hmm.
So I think it's kind of fair practice.
You think it's a fair practice?
I would personally expel women from it, just from the point of solidarity towards the great good of the thing. But if you see it like that, I think it's fair.
It's fair. Okay. What others think about this practice? Of course, take into account that probably Martin is right because we are talking about the case from 1997. Now, with artificial insemination, women can become parents and become mothers much later than they used to be. So probably that was the rationale. So, but do you think that it was okay to exempt women? Dushanka?
That's the
Mm-hmm. Mm-hmm.
That means what if this person doesn't have children at all?
So unmarried?
So you just pay until he's 5.
Yes.
And he doesn't have children throughout his whole life. but still.
But from, yeah, or from 45 to 65, you think it's discriminatory?
Yeah, because if we, our decision, if we want that. So, I mean, I don't see if I have 65, if I am 65 and I'm a man, and I just don't want to have children, you know, but I'm able to provide opportunities when I'm able to.
Mm-hmm,
You know,
mm-hmm. Mm-hmm. Okay, Martin is objecting.
Everyone in the society benefits. Of course, it's our individualistic choice if we have children or not. But if we have children, we're able to benefit from it. Don't have children, we pay the others who have
Children.
So burden of having children. Just help them a little bit out. Because you dependent on children, especially when we get older.
Okay, so now you're introducing also another aspect. But yeah, you're absolutely right. That one of the reasons why this was introduced, so for someone who maybe does not understand why it should be introduced, exactly, we have persons who are childless, so they don't have children. We have those who have children. So there's some kind of contribution to those who do not have children, to have those having children, because that money, that tax was taken, was used for schools, for child hospitals, for some things which had a purpose to help those with children in a way. So kind of civil contribution, societal contribution, let's say. But now the reason, just explaining this policy was, okay, we think that we can introduce it. It's also disputable at the beginning, should we introduce that kind of that tax, but it was introduced. And here we have women who are childless, unmarried. They don't have children. They are not paying after 45, if they reach 45, and men at the same age are paying for this contribution. So is it allowed or not? Dushanka said that it's no. Martin said that it's rational in a way, and he explained why. Any other thought on this?
I get both points. I also I get Martin's point that after when you're 25, you can get children anymore. But then on the same hand, if the money is also used like for children's hospital, for general child care, that not only benefits yourself, then it would be discrimination again, because then why only men should pay over the age of 45? It also goes like into the general child care, even if you don't have children. So, question. Really, is the pay is an obligation?
Yes.
And
so for everyone, just for online, yes, this is an obligation introduced by this law. Yes.
Childless women are free.
Yes, they are not paying. Yes.
After 45,
yes.
Because they don't have.
You remember that Palma also tried to introduce very similar tax like some 10 years ago in Serbia. So it was also, disputable here. Okay. Anyone else? So maybe what our colleagues for online think about this case? And is it discrimination? Or, it is discrimination, that's obvious, but is it justified or not? That's another issue. It's men. Because the applicant is a man. He felt discriminated because females were exempt from this tax. Yeah?
Parallel to this.
Sure.
Regarding to the So,
yeah, is there anyone who would like to say something?
I want to say, dear Professor, it is not
Saful, please go ahead.
justified at all. In my sense, it is not justified at all, but it is discriminatory must.
I can't hear you so well, and I'm sorry. Are you asking, is it compulsory?
I don't know. I told that it is not justifiable. Must be not.
You think that it's not fair, yeah? It's not justifiable,
It is
so
not
it's
justifiable.
it is justifiable.
Not justifiable.
Not justifiable. Okay.
Yes, yes,
So
yes.
you will dismiss this. So what you will do, that you are a policymaker, you will introduce this for childless women as well, or you will say, oh, maybe this policy was not reconsidered well.
I want to do a policy here which is balance the man and woman, balance between man and woman.
Good.
In terms of tax and other payments.
Okay, good. Great. Thank you. Any other comments? What do you think about this argument that Martin raised, that understanding that women over 45 cannot be mothers and men can still be fathers, yeah? That it is justifiable based on that ground, yeah?
Well, if I can say something.
Yes, Ksenia, please go ahead.
I know a lot of cases where women were dismissed of sort of any kind of communication regarding children after 45. And ever since the medicine is evolving, we have a lot of cases of women who are able to give birth even after 50 years old. I know cases. It's generally speaking, it is unlikely, but it's not. It shouldn't be generalized.
No, it shouldn't be generalized, but yeah, we also took into account. I don't know if you've heard us. That this case is from 97. So basically, the fact that happened in 91, 92, when it was really, of course, even at that time, it was possible that someone over 45 became mother. But we see with this time limit, we see what was the purpose of exempting childless women, because that's of course that in some cases they still can become mothers, but at the same time that was taken as some average age when it was more or less likely, for them to become mothers. So in a way, the reason for introducing this measure was not to punish women who cannot change the reality, and in a way to maybe motivate men who are over 45 not paying taxes for other children, but maybe their own private or family situation. What was, let's say, what was the rationale of what the applicant said and what then the government said, and what was the decision? So the applicant argued that this tax under this act for him as unmarried childless men over 45 years of age constitute discrimination on the ground of gender prohibited by Article 14. And this was due to the fact that at the time of the events, no similar contributions were exact from unmarried childless women of that age. So what we see from his complaint basically is that if we have married couple who is childless, this levy, this tax was not required. Yeah, but no one basically challenged that. That is, as couples, they're let's say also exempt from this tax. Only married childless man was supposed to pay. So in a way, it was again punishment, not a punishment, but a contribution on the part of someone who can change that perspective easily. At least that was the notion. What was the government's reasoning? So this is extremely interesting. So what the government said, the biological difference, because women were much less likely to be able to have children. So this is what Martin guessed, seeing this age difference. It was assumed, so this is what was really said by the government orally, openly, that women who had no children and who in all probability never would suffered more than men, and it was wrong to impose on such women the additional emotional burden of having to pay contributions. That was the explanation.
What are like the men who are, we say, like they can't get children at all because they're.
That was the issue. So when the government was introducing this law, what we see from the rationale of the government is that no one took into account that there are childless men who are also suffer from not having children because it's not their way of life, how they chose to be, but they can't have children, and they were not exempt from this levy. At the same time, no one took into account that a woman who is over 45, childless, that it's her style, that she chooses to be. And I have so many women around me who do not have children and they never wanted to have children. So basically, if we want to introduce a measure, so that was the explanation also of the European Court of Human Rights. You can't base it on presumptions and on generalization. So you really need to reconsider what kind of tax levy you will introduce. So what the court acknowledged? The court said that states enjoy a margin of appreciation. So what is margin of appreciation? This discretionary power. So they can either decide or not in assessing whether and to what extent the differences in otherwise similar situations justify a different treatment. But consider that for a difference in treatment based exclusively on the ground of sex, there would need to be a very weighty reason. On this basis, the court considered that the justifications offered by the state were not sufficient. So for them, it was not based on the rational elements, but it was a presumption, and it also based exactly on patriarchy that we discussed, on some presumptions on the roles of men and women in having families and also being parents at that age. Do you agree, Martin?
First, I definitely agree that it's such to the reasoning from the government. If they would have taken another reasoning, for example, that men are able to get treatment, so still theoretically direct benefit from that money, would that be a more weighty reason?
Probably, and 97 today, no. Because it should have really a very weighty reason. At that time, it could be, but this rationale, the explanation of the government was so offensive towards many women that the court, of course, acknowledged that and delivered this kind of judgment. But it's good that the government was, let's say, open. That they didn't pretend that there are some other reasons why they introduced this kind of text, but they really openly said what they think and what was the rationale, believing that the court will take that into account. So it's interesting. Of course, we are talking about 97. I always refer to the date of the judgment. At the same time, as I said, we recently had also a politician who wanted to introduce a very similar provision. And basically, it was also based on the idea to have more children and to fight like white plague, how we call it, to have more children born in this country. But of course, that his idea didn't went well with public and especially with women's organizations, and we didn't introduce this policy. There's another interesting case from Germany from 1994. So what we have in this case is that we also have male adults from 18 to 55, but not females, to serve as firemen or to pay a financial contribution. So in some, especially local communities, for such a long time, and I suppose that you are much more familiar with this practice, they were not fire brigades as professionals, but male served in that fire brigade, and they were trained to do that. But if they couldn't do that, then they paid only contributions which were used for fire brigades, which after a while basically replaced that volunteering work, let's say. So what was the reasoning to have this practice? the state says the difference in treatment was objective and reasonable. Fire brigade duty is a traditional civil obligation for males, and the legislator had been taken account of the specific requirements of service in the fire brigade and the physical and mental characteristics of women. The financial contribution was solely compensatory in nature. Exactly. So they relied on physical appearance, on strength, and I said, but it's not a discrimination, because we need to acknowledge that biological differences. Do we have biological differences? Of course. But again, generalizing, because you also have some women very strong and very tall. But I again look at the date when the decision was delivered. For me, it's interesting what the court said. What you would say, what the government said. What do you think that this reasoning was fair enough to pass this derivative reason test? No? Basically, why I'm giving you this case. If we carefully read the facts of the case, what we see is that they can serve to be as a fireman or to pay a financial contribution. But basically, as I told you orally, in time it became only paying contributions, because they were just they were paid. I mean, that levy was used to contribute financially to these fire brigades, which were, let's say, professional fire brigades. And what the court observed, in view of the continuing existence of a sufficient number of volunteers, no male person was in practice obliged to serve in a fire brigade. So that obligation to compulsory serve was non-existent in time. Thus, it held that the financial contribution had in fact lost its compensatory character and became in effect a duty, and in the imposition of such financial burden, a difference of treatment on the ground of sex would not be justified. So, in other words, physical appearance was irrelevant, because those men who were compulsory, in a way, they who needed to pay that contribution, they were not called to be on a duty, to be volunteers. And basically, they just paid contribution. So then, equally, women can also pay the same contribution, no matter about their strength, physical appearance, and all other personal characteristics. So in other words, the court challenged the rationale given by the government. And this is a very usual situation, that that we are introducing a measure, for example, and then we are not reconsidering whether there is still a reason to have that practice, whether the practice lost the effect. And for example, I'll give you an example of another country, in Thailand, for example. If you are a man, you can remarry immediately after your divorce. But if you're a woman, you have to wait 310 days to remarry after divorce. What would be the rationale of this legislation? Maybe, but it was not the rationale. 310 days. She cannot remarry. So she cannot remarry. With a pregnancy, exactly. So this is exactly the date. So if she stays pregnant, then there is a presumption that the father of the child is a father. And basically, or that we don't know who is the child. So the child born will be without parental, without how we call it, a father. Yeah, at least legally, there is no presumption. So there is an excuse to not allow a woman to remarry. But nowadays we have different tests. We can take a paternity test and get very easily information who is the father of a child. Yeah, and even in marriage, the father can object to a paternity test if he is the father or not, because we have this test. test. So this practice shows that sometimes at some point we had some practice which was maybe even in the interest of the child and the interest of the mother. But nowadays, with this new tests which are emerging, there is no reason to have this condition in the law itself. So this is what exactly this example shows. So in other words, be very careful when we are dealing with cases, and we will now more enter into the cases and analysis of the cases itself. You always have to pay attention on justification. What was the rationale? What was the reason? And reason needs to be in direct, let's say, to be in direct. I forgot even. I can't find even Serbian words for this. To directly apply to that situation in order to be rational. Yeah. Okay, folks, online, do you also have any comments on this case? If not, then let me, while you're here, let me discuss with you. Is there any volunteers? We need 4 volunteers for human rights law course, so not for family judgments, that we will have on not next, but Friday on 26th of January. So we will have, let me see, 26, it's Monday. Yes, it's Monday. So is there any volunteer who would like to prepare a presentation? We will speak about the right to life and about the specific aspects of the right to life. So we will speak about the abortion and restrictions to abortion, honor killing, which also is very much present in some parts of the world, about femicide, and about forced disappearance. Is there anyone who would like to prepare any of these topics? Presentation, I'll send you, of course, information on the elements of the presentation. Presentation should be 20 minutes to half an hour long. Any volunteer?
I can volunteer.
Xenia, for which topic?
If I understood correctly, can you please repeat?
Yes, I'll repeat. So we have abortion, honor killing.
I will do that.
Abortion.
Yeah.
Okay, Xenia, great, excellent. Of course, I can also help you, and you can always come to me with some additional questions. Also, abortion, honor killing, femicide. Okay, and forced disappearance. Anyone interested? Okay, if you're not, of course, if anyone changed the mind, please come to me over the weekend. If not, then we will close with these 3 presentations.
For 26, right? We should
26 Monday. Yes. So you have like 10 days, exactly 10 days to prepare it. Okay, great. I'm happy that we have so many volunteers for these presentations, and I also sent comments on these presentations to Professor Tanasiev, who will examine you for these boards. Anyway, have a great, not only night, unfortunately left, but also great weekend, and see you soon.
Okay,
thank you so much.
Thank you, Professor.
Thank you.
Thank you.
Hawala puno, lakunoch.